response, how can we adjudicate on this
So
issue?
we have, otherwise I'm praying that next week any date may be fixed.
You say that there is already an adjudication by the
Absolutely.
board, and there
Only the
has,
following action has to be taken, that's all.
but the FIR that was filed, that has returned in final report. You had filed an Naraji petition. What happened?
I don't know what steps happen in that phase, but so far as my caste status is concerned, there when I took up the matter, the directions were given.
You have already got a job.
No. We have not.
You're
still-
captain.
I do not know whether I have the job or not.
You are a captain.
No, he was under training, my lord. He was not in a job, if I know correctly.
And he was discharged.
No. He didn't even qualify for a job.
But how did he get the title captain?
I'll have a word with him and get back, my lord. Not with him, but I'm sure he's not in the job. Otherwise, you would have called me up to tell that. 100%. Because as a legal aid
It's
counsel, you
around
have to have told
30,
me.
35 years now.
Should be. And that's why I pray, my lord. Let it be coming on Monday, Tuesday, Wednesday, Thursday, anyway.
If they don't file an affidavit, how will we proceed with this matter, Mr.
So we will do that. We will file
When?
affidavit.
Today.
Yes, sir.
Today you are filing? Huh? Okay, miss. When are you filing?
File it. We will file today.
Today?
Yes.
Are you sure?
That's the matter.
Today?
Yes.
Okay, Miss R.M. Deca, Standing Counsel, Social Justice and Empowerment Department submits that an affidavit on behalf of the respondent represented by her would be filed by 11/8/2025. Registry to list this matter again on 18/8/2025. In the meanwhile, the petitioner is at liberty to bring on record a rejoinder to the affidavit filed by the respondents in the if so advised.
Okay.
18, huh? 18. Yes.
My lord, I beg to mention item number 16, my lord. My lord, our senior Mr. Mahmood had to leave for Bongaigaon, my lord. His brother.
You have got your file.
Yes, my lord.
Got your file. A prayer is made on behalf of Mr. M.U. Mohammed, learned counsel for the petitioner who is stated to be out of station. For prayer is not objected to by the. Have you taken the consent?
Yes, my lord.
Not objected to by the learned counsel for the respondent. Accordingly, registry to list this matter again after 2 weeks on a date to be fixed by. Oh. Petitioner's advocate. It is submitted that a prayer is made on behalf of Ms. D. Kalita for an adjournment in the matter on the ground that she is indisposed. Prayer accepted. The registry to list this matters again after 3 weeks on a date to be fixed by.
Please, your lordship. Lordship, I'd like to mention for listing of a writ petition for orders, lordship.
Go before the senior bench.
Daily list one, deliver of order.
Heard Mr. P.K. Deca, learned counsel for the petitioner. Also heard Ms. R. Devi, learned CGC, appearing for the respondents number 1 to 5, and Mr. S. Doctor, learned senior counsel, assisted by Mr. S. Doctor, learned counsel, appearing for the respondent number 8. You are respondent number 6. 8. There was an amended cost yes. Respondent number 6. None has appeared for the respondent number 7(1) and 7(2). Also, the petitioners in the present proceeding have prayed for being authorized the family pension and other pensionary benefits in respect of the services rendered by their father/husband, late Kajal Chandra Day, with the Indian Air Force and thereafter with the United Bank of India. Also, the facts in brief requisite for adjudication of the present issue is noticed as under. Also, Kajal Chandra Day was an employee of the Indian Air Force and had retired from his services therefrom on 28/2/1985. Also, thereafter, in the month of 1986, he had joined as a clerk with the United Bank of India, Guwahati, bracketed respondent number 6, and had continued in his services therein till 26/1/2001. Also, it is projected in the petition that the said Kajal Chandra Day had married one 80 Day on 24/9/1979, after she had gone missing, said Kajal Chandra Day had married Srimati Sheila Day, the original respondent number 7 in the present proceedings, on 4/12/1988. Also, out of the wedlock of said Kajal Chandra Day and Sheila Day, two sons were born. Two sons, namely Sagar Day and Suham Day, that is the respondents number 7 bracketed 1 and 7 bracketed 2 were born. Also, it is also projected that said Sheila Day had left the residence of Kajal Chandra Day in the year 1993. Also, on being deserted by said Sheila Day, Kajal Chandra Day had instituted a proceeding for divorce before the divorce being case number FC bracketed civil 88/1999 against said Sheila Day. Also, Sheila Day in the said proceeding had filed a petition being petition number 576/1999 on 15/9/1999, praying for grant to her of Pendelite maintenance, which was accordingly granted by the said court. Also, it is at this juncture that the petition number 2 contents that Kajal Chandra Day had solemnized marriage with her on 2/3/1995 as per Hindu rites and rituals. Also, out of the said wedlock, the petition number 1 herein was born on 22/1/1997. Also, said Kajal Day in the year 2001 had gone missing while traveling from Hyderabad to Guwahati, and accordingly, police cases came to be registered in this connection. Also, the petition number 2, petitioners contend that in the year in the month of December 2015, they had received a death certificate of said Kajal Chandra Day from his brother Prolay Kanti Day. Also, having come to learn that said Sheila Day, by projecting herself to be the wife of deceased Kajal Chandra Day, had, after obtaining a death certificate, also received the retirement benefits of late Kajal Chandra Day. Being so aggrieved, the petitioners had filed an FIR before the police of the Fatasil Ambari police station. First up, the said FIR was registered as Fatasil Ambari PS case number 814/2015 under section 417/420 IPC. Also, however, the said criminal petition, the said proceedings in the said police case was under stay in a criminal petition filed before this court by the respondent number 7 and said Prolay Kanti Day. Also, the petitioners further project that the respondent number 7 had instituted title suit number 368/2008, praying for a declaration that her husband, late Kajal Chandra Day, was missing for last 7 years, and accordingly he be declared to be dead by drawing a presumption under section 108 of the Evidence Act. Also, the trial court wide order judgment and order dated 7/4/2011 passed a declaratory decree to the effect that Kajal Chandra Day had since passed away. Also, the petitioners contend that being the daughter and the wife of late Kajal Chandra Day, they had initiated steps for being authorized family pension and other pensionary benefits. It is also projected in the writ petition that as on the date of filing of the writ petition, the petition number 1 had not attained the age of 25 years and was unmarried, and accordingly she was entitled to the benefits of pension and the family pension in respect of the services rendered by her father, late Kajal Chandra Day. The respondent authorities, having not considered the grievance of the petitioners herein, they have instituted the present proceedings. Mr. P.K. Day, Learned Counsel for the P.K. Decca, Learned Counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that the petitioner number 2, being the wife of late Kajal Chandra Day, and the petitioner number 2 being the wife of Kajal Chandra Day, and petition number 1 being their daughter, the petitioners are entitled to receive family pension are entitled to be authorized family pension in respect of the services rendered by late Kajal Chandra Day with the Indian Air Force and subsequently with the United Bank of India. Also, Mr. Decca has submitted that even if it is to be held that the marriage between Kajal Chandra Day and the petition number 2 is not valid in terms of the Hindu Marriage Act 1956, Hindu Marriage Act, Hindu Marriage Act 1956, the daughter, although the petition number 1, although petition number 1, even if held to be an illegitimate daughter, she would be entitled to pension and pensionary benefits. Also, in this connection, he has placed a reliance on the decision of the Honorable Supreme Court rendered in the case of Rameshwari Devi versus State of Bihar and others, reported in AIR 2000, Supreme Court 735. Also, 1955 day. Also, Mr. Decca has further submitted that itu replace reliance on Rameshwari Decca. In the support of his such submission, Mr. Decca has placed reliance on Section 16 of the Hindu Marriage Act 1955 to Section 16 of the Hindu Marriage, wherein the legitimacy of children born out of void and voidable marriages have been upheld. Also, has been provided for. Full stop. Further, he has placed support of the decision. Further, he has placed support of the full stop. Mr. Decca has submitted that the respondent number 7 was the original respondent number 7, that is Sheila Day, by playing fraud, had obtained a declaratory degree from the trial court, and basing thereon, she had drawn the family pension and other pensionary benefits with regard from the respondents with regard to the services of late Kajal Chandra Day. Also, Mr. Dekka has further submitted that the petitioners, the petitioners being the next of kin of late Kajal Chandra Day, there exists no bar in the respondent authorities releasing to them their due family pension and other pensionary benefits. Also, per contra, Ms. M. Devi, learned counsel for the learned CGC appearing for the respondent number 1 to 5, has submitted that in the service records of the petition of late Kajal Chandra Day, the name of his wife has been recorded as Srimati Eti Datta. However, on original respondent number 7 hearing, Sheila Day, having approached the authorities, claiming to be the legally wedded wife of late Kajal Chandra Day, and she having produced a declaratory decree issued by the Court of Munsif number 3, Kamrup, drawing presumption with regard to the death of late Kajal Chandra Day, her name came to be recorded as the next of kin in the service records of late Kajal Chandra Day, and subsequently family pension was sanctioned to her with effect from 18 to 2021, 18 to 2001. Also, Ms. Devi has submitted that in the service records of the petitioners maintained by the respondents represented by her, there is no reference of the petitioner herein marrying of late Kajal Chandra Day solemnizing marriage with the petition number 2 herein, and or of the petitioner number 1 being so born out of the said wedlock. Accordingly, she submits that the claim of the petitioners herein she submits that the petition number 2 cannot be deemed to be the wife of the petitioner of late Kajal Chandra Day, and accordingly, the lineage sought to be drawn by the petition number 1 through the petition number 2 to Kajal Chandra Day would not mandate an acceptance by this court. Also, Mr. S. Dr. Learned Counsel for the it's United Bank or Punjab National Bank? Learned, okay. Learned Standing Counsel, Punjab National Bank has submitted that there is no record available in their, therefore has submitted that the service records of late Kajal Chandra Day does not reflect that the names of the petitioners herein have been incorporated therein as his legal heirs. Also, it is further projected that there are no documents available with the bank to show that late Kajal Chandra Day had married the petitioner herein. Also, the senior counsel has further submitted that on the declaratory decree as noticed herein above being produced before the bank authorities by the original respondent number 7, that is Srimati Sheila Day, the retirement dues of late Kajal Chandra Day was released to her. It is further submitted that the late Kajal Chandra Day had subscribed to the contributory pension fund scheme, and the amount as accumulated in the said fund has already been released to The original respondent number 7 herein, Srimati Kajal, Srimati Sheila De. And no further amount is due for release to any of the family members of late Kajal Chandra De. Also, accordingly, the learned senior counsel has submitted that the claim made by the petitioner cannot be entertained by the accordingly the learned senior counsel submits that no terminal benefits being due to be released in respect of the services of late Kajal Chandra De, the claim as made by the petitioners in the present proceedings, who are the Punjab National Bank, would not mandate an acceptance from this court. I've heard the learned counsel for the parties and also perused the materials available on record. Also, the projection made in the present petition is with regard to is to the effect that the petitioner number 2 is the wife of late Kajal Chandra De, while the petitioner number 1 is his daughter. True, the petitioner number 2. Also, while the said contention has been raised in the present proceedings, and the same is being sought to be established basing on the birth certificate of the petition number 2, by contending that therein the name of Kajal Chandra De has been reflected as her father, her educational certificates, as well as the PAN card and the voter ID card issued in the names of the petitioners, wherein the name of Kajal Chandra De has been reflected, the petitioners seek to establish that they are the next of kin of late Kajal Chandra De and would be entitled to be authorized the family pension and other pensionary benefits due to the family members of late Kajal Chandra De on account of the services rendered by him both with the Indian Air Force as well as with the Punjab National Bank. Also, this court, on perusal of the materials brought on record, finds that there is nothing available which would conclusively demonstrate that Kajal Chandra De had married the petition number 2 on 2/3/1995, and that out of the said wedlock, the petitioner number 1 was so born. It is seen that the petitioners herein, as of 2000, petitioners herein, while lodging an FIR with regard to against the respondent number 7 and one Praloy Kanti De, brother of late Kajal Chandra De, were aware of the fact that Shilpa De had instituted a title suit number 368/2008 before the Court of the Municip number 3, Kamrup, praying for a declaration that her husband, late Kajal Chandra De, had already passed away, by drawing a presumption as available under Section 107 and Section 108 of the Indian Evidence Act, on the deceased being missing for past more than 7 years. Also, it is seen that in spite of the said fact being to the knowledge of the petitioners herein, no steps were taken by them to have the said declaratory degree annulled by instituting appropriate proceedings in accordance with law. Also, although the Although said Kajal Chandra Day is projected to be missing since 2001, the petitioners have waited till 2017 to approach this court, praying for the reliefs as sought for hearing. Also, it is seen that the petitioners had approached the respondents of praying for release of the pensionary benefits due on account of the services rendered by them by late Kajal Chandra Day, to them only in the year 2016. Also, the materials brought on record not being conclusive to establish the marriage being solemnized between late Kajal Chandra Day and the petitioner number 2 hearing, this court in the present proceedings would not be in a position to accept the contentions raised in the matter by the petitioners. Also, the petitioners ought to have approached the a competent court of civil jurisdiction for a declaration to the effect that the petitioner number 2 is the wife of late Kajal Chandra Day, and that the petition number 1 was so born out of the said wedlock. Also, the learned counsel for the petitioner, by referring to the provisions of Section 16 of the Hindu Marriage Act 1955, has submitted that even if the marriage between Kajal Chandra Day and the petition number 2 is held to be void, the petition number 1 being born out of such wedlock would be a legitimate child, and she would be entitled to the service benefits due on retirement, due on account of the she would be entitled to the retirement dues on account of the services rendered by her father, late Kajal Chandra Day. Also, the said contention, in view of the materials coming on record, would not mandate an acceptance, inasmuch as the factum of solemnization of marriage between late Kajal Chandra Day and the petitioner number 2 cannot be said to have been established in the present matter. Also, the learned counsel for the petitioner has further placed reliance on the decision of the Honorable Supreme Court in the case of Rameshwari Devi bracketed Supra, and has contended that the Supreme Court therein had held that even if the marriage of an employee, the second marriage of an employee is held to be void, the children born out of such marriage would be entitled to the benefits of pension and pensionary benefit, would be entitled to pension, family pension, and other pensionary benefits. Also, this court has closely perused the decision of the Honorable Supreme Court in the above noted case, and finds that therein the second marriage of the husband of the appellant, who was the first wife, was not disputed. What was in issue in the said proceeding was that the second marriage being void, the children from the second marriage would also not be entitled to any, would be illegitimate and would not be entitled to a share of the pension and pensionary benefits of the husband of the appellant therein. The Honorable Supreme Court, on consideration of the matter, by noticing that the second wife had lived as husband and wife with the employee concerned therein since 1963, a presumption arises that marriage of the second wife with the employee concerned was in accordance with the Hindu rites and all ceremonies connected with a valid Hindu marriage were performed, which the appellant therein was unable to refute. However, the Honorable Supreme Court held that the second marriage of the employee, being in contravention of Clause 1 of Section 5 of the Hindu Marriage Act, was a void marriage. However, the Supreme Court held that under Section 16 of the Act of 1955, children born out of a void marriage were legitimate and accordingly proceeded to uphold the decision of the Division Bench of the Bihar High Court of Patna, uphold the decision of the High Court involved therein to also authorize a share of the pension and pensionary benefits to the children of the second wife. Also, the facts involved, applying the decision of the Honorable Supreme Court in Rameshwari Devi, bracketed Supra, to the facts of the present case, it is seen that in the present case, the factum of marriage of the petitioner number 2 with that of Kajal Chandra Day is not established, and accordingly, it is not permissible for this court to hold that the petitioner number 1 is in fact the daughter of late Kajal Chandra Day. Also, in view of the above conclusions, this court is of the considered view that the relief sought for by the petitioners in the present proceeding would not be mandated to be so granted. Having drawn the above conclusions, this court grants liberty to the petitioners to approach the competent court of civil jurisdiction and to get a declaration to the effect that the petitioner number 2 is the wife of late Kajal Chandra Day and the petitioner number 1 was born out of such wedlock. In the event such declaratory decree is issued in favor of the petitioners herein, they would be at liberty to approach the respondent authorities staking a claim for being authorized a family pension. Full stop. The other family pension benefits, the other pensionary benefits having already been authorized by the respondents to late Sheila Day and the petitioners themselves in the present proceedings having accepted the fact that Sheila Day, that is the original respondent number 7 herein, was the wife of late Kajal Chandra Day, the petitioners under such circumstances would only be entitled to the family pension and not the other retirement dues that was available to be released to the heirs of late Kajal Chandra Das for the services rendered by him with the Indian Air Force as well as with the Punjab National Bank. With the above observations and directions, the present writ petition stands disposed of. Yeah. Bara delay home. Bara delay. Yes.
Regarding my compulsory.
Yes. Let him go.
Definitely.
To me. Itu na marijuana lagate. Order gita might. But Mr. A.Y. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. You are for respondent number 1 also. Heard Mr. C. Burwa, Learned Standing Counsel, National Highway, NHIDCL, appearing for the respondent number 1, 3, and 3. Also heard Mr. J. Handick, Learned Counsel, appearing, Learned Standing Counsel.
Yes, he's there.
He's standing counsel.
And you are appearing for response number 2. You 4 and 5. And 2? Oh, Miss N. Bodler, Learned, Standing Counsel, Revenue Department, appears for response number 2. Also, Mr. J. Handick, Learned, Government Advocate, appears for response number 4 and 5. And Miss R. N. Borua, Learned Counsel, appears for the response number 6. Also, taking into account the dispute involved in the instant writ petition, this court is of the considered view that the present writ petition can be disposed of at the motion stage itself. The learned counsel for the parties have also agreed to the disposal of the present writ petition. First, as projected in the writ petition, the petitioner is the owner of a plot of land measuring 7 katha, covered by dark number 286, Patta number 109, situated at Kalinagar, Part-Roman Dangar 1, comma, in the district of Hailakandi. It is projected that the said land was acquired by the NHIDCL authorities for expansion of the national highway under the provisions of the National Highways Act 1956. The petitioner further projects that the said land, although being a purely commercial land, the respondent authorities, while computing the compensation required to be authorized to the petitioner for such acquisition of his land, had paid inadequate compensation by considering the value of the land at a very lower rate. Also, it is further submitted that the compensation as computed in the matter was so done in clear violation of the provisions of the National Highways Act 1956, read with the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Also, Mr. Chaudhary, Learned Counsel for the petitioner, has submitted that he has already approached the respondent authorities by way of preferring a representation in the matter on 10/2/2025, right? Praying for enhancement of the land compensation. However, the same is yet to be taken to its logical conclusion. Full stop. Subpara. It is under these circumstances that the petitioner herein has therefore approached this court by way of filing the instant writ petition. Episode para 7, para 8, para 9, para 10, para 10. Disposed of. There are other 2 matters. Which are those?
It is item number 3, similar, my lord, only the dag and land.
I'll have to dictate that. Item number 3, dear.
Allah. But he has.
No, I've now directed that.
Yes, to DC. And DC will do needful now. That
No, he has submitted an application before the competent authority, whoever the competent authority is.
Yeah. In other case may be done.
Itu tumar baki soap. Rest are same, parties are same. A para 2 eke thakibo. Miss R Bora koi diba. C Borua jagat R Bora koi diba. All baki eke thakibo. 2 para 2 eke thakibo. 3 tulwa. The petitioner in the present proceeding has projected that he is the owner of 3 plots of land measuring bracketed A, 21 katha bounded 21 katha covered by RS Patta number 123, dag number 315, semicolon, B 12 katha covered by the, how can it be same katha, same patta and same dag, both the land?
Under Dag number আমার পাট্টা
এনেকা লেখা বাদ দিয়া। The petitioner in the petition has projected that 3 parcels of land belonging to him were acquired by the NHIDCL authorities for construction, for expansion of the highway under the provisions of the National Highways Act 1956. It is submitted that the plots of land of the petitioner, which have been so acquired by the respondent authorities, are situated in commercial as well as homestead properties. Also, the respondents, while computing the compensation due to the petitioner for the parcels of land acquired from him, had so made the computation by construing the value of the land at a very low rate in clear violation of the provisions of the National Highways Act 1956, read with the provisions of the Right to Fair, 2013 Act. Mr. Chaudhary, learned counsel for the petitioner, has submitted that the petitioner has already submitted a representation in the matter before the respondent authorities on
4/1/2025.
24/1/2025 for enhancement of the compensation. However, the same is yet to be taken to its logical conclusion. Para 6 or last para 11 ole maidiba. Next, item number
My lord, similar.
Madam Boy, you are appearing? Huh?
Very on behalf.
R.K. Talukdar. Democratic process. A R. Bora, C. Burua's zagat, R.K. Talukdar koi diba. Baki eke thakibo. Rest is same
Same.
also. Yate khali para 2 to 2 loilo. Baki sob eke thakibo. Para 2 or 3 mati kotha jo tu koisu moi. Para 2 or 3 loilo. In the petitioner projects that he is the owner of land measuring 15 kata covered by dag number 315 and RS Patta number 123, situated at Porgona, Haila Kandi. Also, the said land was acquired from the petitioner by the National NHIDCL for expansion of the National Highway, under the provisions of the National Highways Act 1956. Next paragraph 2, 4 opera. Eke thakibo. Khali tomar a date of representation.
It is 30/12/2024.
30/12/2024. Also, dispose of. Go back into it.
Right.
But you'll not get the orders before Monday.
Right.
Yes. Mr. Sharma, you had bought the land from a Khatiyandar.
No, first one is not that, my lord.
First one is 4456.
Yes,
This is
4456.
this is your mother had brought this land from one Rabha who was a Khatiyandar.
Yes.
Now, this land, you had been occupying this land since then. Have you been paying government revenue against that?
Yes, sir.
Where have you stated? Your father was paying. No issue on that.
That annexure E is there, page 22.
Page?
22. And there 24 also.
Now the LAC has taken a decision to
They-
allot that
they-
land in your name.
Yes, yes.
What happened after that?
Thereafter, my lord, we filed a press application before DC.
This is for mutation. You are not the landowner. The land has not come in your name. You have only a transferee of a Khatyandar from a
Yes,
Khatyandar,
yes.
tenant.
Yes.
But you have not got the settlement.
My lord, this,
How can there be a mutation now?
that resolution is there, my lord.
Resolution is there. What happened thereafter?
Thereafter, my lord, that we filed a press application before DC. That has not been disposed of, my lord.
This cannot be. This application 5.3
Yes.
is for mutation. How can we allow that?
My lord, but nothing has been
That is a different. You come with an application that the settlement which was approved by the LAC, that has to be taken forward. We will see. But that is not the prayer here. How can there be a mutation of a Miyadi Patta in your name? You are never it's somebody else sealing case. Some zamindar somewhere. Now, how can that be? I don't know. I'm asking you.
But then, my lord,
This mutation is when you are bought a land, Miyadi land,
Yes.
you brought it,
yes,
but you never brought a Miyadi land. You only got the possessory rights.
but that settlement has been approved, my lord.
Ooh, that is just a proposal, recommendation.
Yes.
Where is the allotment? Where is the payment of premium?
Thereafter, nothing has been
Then-
taken.
You have not prayed for taking that too. You only prayed for mutation. I'm sorry, that cannot be allowed.
My lord, we'll withdraw the petition, then we'll file the application.
Very well.
Both the matter, my lord, 4 and 5.
Because let us not do something indirectly what cannot
Yes,
be done
yes.
directly. Heard Mr. J. Sharma, Learned Counsel for the petitioner. Also heard Mr. B.J. Talukda, Learned Senior Counsel, appearing for the state respondents. And Ms. Ms. N. Bodloy, Learned Standing Counsel, Revenue. Also, Mr. J. Sharma, Learned Counsel for the petitioner, after attempting to argue the matter at some length, seeks to withdraw the present petition with liberty to approach the respondent authorities with a prayer for settlement, with a prayer for consideration of his with a prayer for settlement of the land under his possession with him. Also, prayer is not objected to by the Learned Counsel for the respondents. Also, raised in view of the above submission, the present petition stands dismissed on withdrawal.
Similar order may be passed.
Item number 502, same order. Same as 4. You approach the Kala. He'll refer it to arbitrator.
Close, Lordship. I submitted application.
See the annex.
Close application is Lordship page 50. Already approached before the Kala Lordship. Page 50.
26. What do you want to say?
My lord, that land has been recorded as a, my lord, Ailura.
Saliora, Mensa, teak plantation.
At present, the present land, the aforesaid.
You receive your instructions. Mr. J. Hendick submits that he be granted a week's. You get that land, you get that instruction, get that written instruction. Heard Mr. F.E. Borbia, Learned Counsel for the petition. Also heard Mr. J. Hendick, Learned Government Advocate. Also, and Ms. R. Bora, Learned Standing Counsel, NHIDCL Limited. Mr. Hendick submits that he be granted 2 weeks' time to complete his instructions in the matter. Prayer accepted. Registry to list this matter again after 2 weeks for motion on a date to be fixed by. Let them get that instruction.
Lordship. Next date.
Two, respondent. I've given 2 weeks. In the meantime, you can.
The Muslim matter in
It will automatically come, Mr. Bobby.
obliged.
You want us to issue a direction for amendment of the, can we do that?
Lordship, it's at least interim can be allowed. One reason is that as per the Amendment Act, Lordship, as per the Amendment Act, I just want to, this 23 portion, Lordship. If we consider also as a juristic person, because he belongs to a transgender community petitioner and representing an organization, Lordship, in organization's name, he is going to purchase the land. Already permission is being granted. The fee for women is 1%. Men and women together is 2%. And for juristic person is 3%. But here they have charge as 5%. The analysis is there in Annexure 7, Lordship.
It's already charged.
Since they have quoted, so we have to submit, then everything will be done. The process pre-registration summary, Lordship, page 53. Stamp duty, Lordship.
9,75,000. This
Yes.
is 5%.
Is 5%.
Because it's a why 5%? Because it is a
Juristic person.
juristic person.
Yes, then it would have been 3%, Lordship, as per the statute.
Yes, Mr. Bora. You are not,
Yes, Lordship.
Mr. Handik. What is this? This is in where is it?
It's in Nunmati, Lordship.
No.
What, Lordship?
Buyer's particulars,
Yes, Lordship.
Anazori.
Yes.
If it is Anazori, it's a juristic person. We'll have it on Wednesday because we can't keep them waiting. And the issue raised herein is a serious one. Maybe we will not be in a position. 13. But
Lordship.
now the law is that this is a separate category altogether. We have to treat them. And that has now been, by the Nalsa judgment, that has been given a quietus. So here also, this category has to be introduced. Whatever rate you fix, that is a different thing altogether.
Yes, Lordship.
But it cannot be the same as men. There has, because they are now a recognized class. In all other aspects, avenues, you are treating them as a separate class altogether. Now, even the question of reservation is underway, is under thought process, thought is going on.
Yes, yes.
So, they'll also require land.
And in Delhi, they are being charged as women. The
Even as it, that we can't say. That is for them to, that is for them to do. But it cannot be 3%. Anyway, that is for the government to decide. No.
Urgency is there. Lordship.
There is urgency. This is time bound. This projects land they'll get. They might get some sanction, some grant from some place. So why delay? Because this is for a beneficial purpose. Let us not have an adversarial thing here. Because this is not being done for the person concerned. He is doing for a community. It's for a community development. Okay.
Espousing the of the transgender community.
Heard Ms. D. Ghosh, Learner Council for the petitioner. Also heard Ms. N. Bordeloi. And also heard Mr. J. Handik, Learner Government Advocate, appearing for the response number 1, 3, 4, and 5. Also heard Ms. N. Bordeloi, Learner Standing Council, Revenue Department, appearing for the response number 2 and 3. Also, Mr. S. Bora, Ms. Bora appears for the response number 6. Also, Mr. J. Handik admits that given the nature of the relief sought for by the petitioners herein, more particularly the interim relief sought for, he be granted a week's time to complete his instructions in the matter. Also, prayer accepted, raised a prayer accepted. Registry to list this matter again on 14/8/2025. We'll have it on 13. If not, one more day we'll keep 13/8/2025. Mr. Andik shall complete his instructions in the matter and apprise this court of the stand of the respondents represented by him on the next date of listing.
Deeply.
Hi. Item 9 affidavit has not been filed by the respondent number 1 and 2. He has filed. My prayer is with regard to the suspension order.
Now, what happened to the selection process? Ms. Borua, what happened to the selection process? October. Some ISRO people will also be coming down. Or physics department of Gauhati University is being involved. Complicated issues. Why this October 25? Just for the fun of it. Fun of it. Take one day.
For my instruction, my lord. Interruption, my lord. My lord, new service rule is coming, my lord. So that will be, my lord.
That cannot be the ground, Mr. Monta. That cannot be the ground.
One ground is there, my lord. Because
You show me the law. Show me the law.
No, this is, I know, my lord. I will consider the lordship that the existing rule will prevail. But even then, there is some defects and some anomalies are there because the promotion, but the posts are not there, some posts.
We are passing an order
So
that this whole thing was for 2 months. This cannot be continued. Let the government manage it on your own.
No, my lord, one
You
thing,
cannot continue.
Recommendation is pending since 2019.
I know that.
my lord,
You
one-
cannot continue.
My lord, lordship, one thing can consider. Some post.
The rule that is there today,
that
it says 2 months. You have exceeded 2 months. Let the commissioner and secretary take over charge of that post
Yeah.
and run the office.
That will do.
You
that
have
will do.
the
That will
selection.
do.
When are you retiring?
My lord, in the April,
Next April.
next April.
Okay.
And since 2019, my lord, recommendations are pending.
Mr. Not, have I said till now anything which will go against you?
No, man.
Then you take your seat.
One thing.
When a senior is arguing, please let him argue.
Can have a-
It's anxiety. Okay, Mr.
But one thing, my lord, as the process has already been initiated, my lord, that will be done by the October only. So that may be, my lord.
That will be done by October. Let it be done by
Oh.
October, November, December, January. After his retirement, we are
No, no,
least
that will be-
bordered,
that will be by positive.
but we will go by the rule.
That will be positive by my lord, October, my lord. This is a new rules is coming because certain posts, the additional director post is CPS.
Mr. Monto, you are the respondent number?
Three.
3.
Yes.
You,
One thing, my lord, one senior, my lord, lordship, it's some, for moment, my lord, bear with me, my lord. The one post, that is the additional, my lord, additional chief inspector of boiler, that post is not there. So that post has newly, my lord, inducted the new, my lord, service rule. That is why.
his submissions would be valid in item number 10.
Yes.
No,
Nine.
in item number
No, 10.
10.
10, yes. So for a 9 is there, well, I have nothing to say. But regarding the promotion, well, everything is all said. It is to be completed by October, my lord. Only on the basis of the rule, my lord. If then, my lord, lordship can give it a direction in the existing rule. That will be completed by October, my lord.
No,
But if it is.
by October, you have been given this charge. And this charge cannot be given to you. Dehors the rule holding the bill today.
Not my own, my lord, to will and my lord wishes, my lord. This is by the
Fine,
government.
that is better. Thank you for that. We will record that also.
One thing, my lord, lordship, bear with me.
That you are there only because the government wanted you.
Because government want to make the everything in streamline. That is why, my lord, new rule is coming, my lord. Because now, for he might, definitely he will also agree. Because, my lord, certain posts are not.
Yes, Mr. Ms. Borua.
That is why new.
We are directing you to do away with this ad hoc arrangement and fill up the post within a period of 1 month.
Only 1 month. Only 1 month.
Or October, in October it will be.
Okay, I'll ask the commissioner and secretary to take over the charge of this post. He'll not be allowed to continue. Anything more?
Only, my lord, 1 month. how it is, my lord, is August is going on, my lord. Only September, only part is on, my lord.
You tell me, Ms. Barua, how this continuation is being made? Because para 12 of your service orders.
Page 24.
Sorry. Where was that?
Page 24, rule 12 of the circuit rule.
Temporary appointment for a period not exceeding 2 months may be made by the governor at his discretion. Beyond 2 months, even the governor does not have a discretion. This post will be manned by the commissioner and secretary. And you hold this election whenever you want.
Yes, my lord. Only one, my lord.
Who? To retire.
No, he's holding the post for 1 month extra, my lord.
Be that as it may,
My lord,
2 months.
my
How
lord,
can I go? See, Mr. Monto, if you can show me that these rules are not to be complied with.
Rule is not permitted, my lord. The thing is that how it is done, it is not that there's some arbitrary things has been done.
Okay.
It is only.
But Mr.
No, my lord.
S. Not
That's it, my
learning.
lord.
10.
Only, my lord, one thing, my lord. Because, my lord, I was given the charge not by one person, my lord. It is of the, my lord, scrutinized by the authority concerned and on the basis of the.
I am not concerned. I am only concerned with this 12. I'm making an interim order. I'm only concerned with 12. If your appointment is within 12, nothing like it. If not, it has to go.
But subsequently, my lord, I have been given the power, my lord, to do the all.
Whatever power you give, administrative power you are given, that power cannot go beyond the provisions of Rule 12.
I concede, my lord.
It's a rule.
Rules saying many things, my lord. That is not been followed in case of the, my lord. The,
Either as it may.
so, my lord,
So-
one thing, my lord. Already, my lord, everything is in set, my lord. This completed by only after 1 month, my lord. This nothing will happen
is-
during this thing.
Mr. Bonto, that Mr. Borua is not. Borua says October.
October.
You are not the authority.
Kind of set a date.
You are not the authority.
I am not the authority, but if it is something is happened, my lord, some
Something has happened, the government will take care of that. Nothing for you to worry.
lordship only consider these things, my lord. They have coming with the all implementation of the as per your lordship order, my lord.
Where? What implementation? They have not implemented. October implementation is not there. What you are saying is not there in the communication.
No. They are, my lord, saying that within October they have completed because, my lord.
Okay,
as per
let
my-
them complete
no,
by
my lord,
October.
as per
Till
my-
October, the commissioner and
as per my
secretary.
instruction-
What is your interest?
I am not in-
You are only an ad hoc
No, no.
thing.
No, my lord, I only one interest.
No prejudice will be caused to you.
Only one interest is this, my lord, because if new rules is coming, then I will be benefited, my lord. This is the
Maybe.
interest, my lord.
Okay.
So one thing, my lord, lordship, already my lord, personnel department has cleared the, my lord, rule. It is now it will be adopted through the, my lord, this is finance and then the LR, then after the cabinet decision will take, and after the.
It'll take another year.
My lord.
It will take another year.
No, now the cabinet is sitting in everyone, my lord. There is no problem.
Okay, fine. That is,
Sitting, my
if the government takes a decision in that direction, you come back.
All right, my lord, but this decision that will be harsh to me, my lord. Lordship, whatever is, my lord, contemplating to pass the order, my lord, that will harsh to me. Because I have, my lord, since.
Mr. Bonta, what is the right you have? You have got no right.
My lord, how I is running the department?
Your seniors are there.
No,
The seniors have not been.
Senior is not the criteria to selection the higher to,
Fine.
my lord, this promotion.
Fine.
My lord, this is the suitability and even how he understand the law and relating to, my lord, things.
Anything more?
My lord, that will be
Anything more?
taken into consideration.
Anything more?
My lord, only one thing.
Today we have some constraint of time.
Yes, I understand, my lord. But one thing, my lord, that I played before Lord.
Okay, I'll hear you again.
Please
I'll
tell-
hear. No. This is the order. We'll hear you on Wednesday and pass the orders on Wednesday. Mr. Kolita, you have anything to add? Stay till Wednesday. Thereafter, we will require the commission secretary to do
Wednesday, I will be out of station.
Okay.
14, my lord.
Thursday.
Boss.
Heard the Learning Council for the parties registered to list this matter again on Thursday for 14 for further hearing.
Awesome.
The order we are tentatively thinking to pass is that Rule 12 does not permit a continuation beyond 2 months.
I'm not,
That-
they were
that
saying
would-
that not apply, my lord. Even my lord.
That will be the end.
My lord, for
Let the
benefit of-
government do whatever
but-
it
but-
wants.
but if the new-
I'm not saying that the petitioner should be
if
put,
even-
Mr. Monto,
This-
Mr. Monto, I'm not saying the petitioner should be put back. I'm saying the government will take a decision.
Yes.
But they will be
But
benefited
that
with this
decision should not be dehors.
I fully agree with lordship, my lord.
Obliged, deeply obliged.
Yes, tell me. Mr. Goswami seems to be very confident that he has a very good case. His appearance is also not required. Mr. Nayak is all pervading. He is there everywhere.
Was also not
My
called.
case is 13.
No, this is something else. You did your correct. Yes, Mr. Bhattakur. Anything left?
Operate the mall, you have. to
No,
sign.
no. This case, that principle may not be possible because he had submitted an application before you for correction of the date of the tenure to extend it. That was pending. You had done nothing. You went up and instituted a Bakijai case. Your affidavit says that he not paying the money, I was left with no other alternative but to institute a Bakijai proceeding. Now you demonstrate that the petitioner was in a position to operate.
At my note, we are not that.
If that is not being disputed, now tell me, Mr. Goswami, who constructed the road?
That alternative road that came out in the later part of the deal, man. That we had spent money.
Oh, how do you expect? But you have not countered the submission, contention of the.
Yeah, that is admitted by them, my lord. By
No. Here.
My lord.
Come to page 66. Page 66, para 8.
It's 66, my lord.
Is internal page, it's a part of that last affidavit filed by 11/6/2025, Ashok Dev Chaudhary. There is an affidavit filed by, you have filed a reply to that also.
I have filed a reply, my lord.
Affidavit to that. Give him the affidavit. Or Ashok Kumar Dev Chaudhary.
Yes, my lord.
You have it? Come to
Right.
para 8. 6 lines from bottom of that paragraph.
Let us say that prior to aforesaid approach road made by the deposit,
Made by the deponent.
the permit holder was directed to deposit the outstanding kiss money against. This was made by us, my lord. We
No, you made by the deponent. Now you come to your reply. At page 78, para 7. You have not even dealt with that.
that is possibly because my this deponent word must have, my lord.
No, deponent means he only.
Yeah.
Now this position being, we can only direct for release of your first kiss money. With interest. Okay. Bank norms.
That is, if that can be done, my lord, possibly.
Because this statement, how can I ignore? He says he has made it. You have not even dealt with it.
This was the private agreement, my lord. I'll just place it, my lord. I'll place it.
Okay, place it.
I'll place it. My lord. I'll place it. This
Para
is-
12, page 12.
No, my lord, I'll
Para
place it.
12.
I'll place the, I have an next. No, this is a failure of the authorities.
Annexure 11.
My lord, quite strange, my lord, that in spite of the combined strength of the magistracy, the police and the forest, they couldn't check it, my lord.
That agreement of yours with the Patadas
Yes, my lord.
is at page 11, page 35.
Yes, my lord. No, thereafter, my lord, NOC was granted by the deputy commissioner and all that, my lord.
No, that is there. But where is the question that you have constructed?
Your lordship will kindly come to page 48 of the writ petitions.
48 of the writ petition. What is that annexure?
That is annexure 12.
12, I'm holding it. It is page.
Regarding
30.
private road for carrying river seal,
Hmm.
with reference to the, this was from the conservator forest.
6/4/2015.
Yes, man. The agreement is in between Lacey and Patadas, maybe in the form of legal documents. So agreement was done by me.
No, but where is that you, after that agreement, you made that road?
Well, that was developed by us, man. District.
Where? Just show me something.
For using the newly proposed road for extraction of minerals from there.
Because otherwise I can't go into that. In your pleadings also, it's not there. Mr. Goswami, go through it.
Or if your lordship, my lord, wants me, my lord, I can place the instance by.
No. We'll no further thing. We'll have to have it from this material only. Maybe there is some line somewhere. Otherwise, it is only revalidation of the first kiss money and the period.
But only one thing, my lord, I do not know, the department would know, my lord. Presently that mining area possibly has been, it is no longer in vogue, my lord, in existence, my lord. My friend would be able to, because there is a road, my lord, a road going by the bank.
Now we can't permit you to, that thing cannot be permitted. The rates you quoted then and the rates that are there today,
Should be made only viable.
sky and heaven, earth and heaven.
My lord.
Okay. Yes, you have a statement. Para 17, page 15.
My lord, your lordship will also kindly see page 54. It is very clear.
54 is?
54, my lord. This is the letter that we had written, my lord, to the commissioner. My lord.
Your writ petition in my book stops at page 44.
Oh.
Which is the one you're trying to? Joint Kolita?
Deep Prasad Das.
Oh, deep process.
Second one.
Oh,
I'm sorry.
is the one.
Page 54. There were 3 Mahals, my lord. One party didn't come. 2 of them are here.
The raid was in connection with all the 3 Mahaldas.
Yes, man. Yes. 54, bottom, my lord. Lordship, presently, we have already developed a private periodic pata land road by entering into an agreement with landowner at Sarapara.
Where?
Bottom, my lord.
54.
Yes, ma'am. For extension, ma'am. Presently, we have already developed a, has your lordship done? The land road by entering into an agreement with the landowner at Sarpara village of Puk Majirgaon area, regarding which road the conservator forest Central Assam Circle has accorded his permission for the road by so and so. The direction to the DFO for seeking NOC from Deputy Commissioner Kamrup, the DFO communicated. Ultimately, NOC was also granted, but they have taken quite a long time.
Yes, Mr. Bothagot. If that road is constructed by him with your NOC, he'll also be entitled to some compensation for that. It's your failure here. The documents which are there of your officers clearly show that they could not. They even approached the commissioner police. Commissioner police also did not respond. Hmm. That letter is there in your first affidavit, also in the writ petition.
The language, my lord, of that letter would show the helplessness expressed by the authority.
Rules are of 13. But have you ever approached him saying that you can give up this, it's not feasible, because he is there. He came before this court in 2016. This was given to him 2013. It was the order came in 2000. When was the
2014, my lord.
2014
14.
for a period of 3 years.
2 years.
So 2 years.
2 years.
So that period would have come to an end in 2016. He came before this court in 2016 itself. Before the period was over, you instituted Bakijai. Right? His prayer was that kindly extend that period. Consider that kissed money and extend the period. That much only. So where is the issue of his giving up the Mahal? The matter became sub judice. Bakijai proceeding was not after his completion, I suppose. It was in the midst of his tenure because he was not paying anything. Right? I know that. He has replied to that also. And even your affidavit, first one, as well as the second one, reflects as Mr. Goswami has rightly pointed out, your helplessness. He is your Mahaldar. You give him a settlement, that is not the end of your responsibility. You must ensure that the environment is there.
Environment has to be brought in by. It is
That
there.
environment, that ambience is there so that he can do his work, pay you the revenue. If the environment is not there, how do you expect him to work? His statement is, he has not even taken out one CM.
It is their officers who had instituted the cases, madam.
FIR by him, FIR by you. Nothing. Final report. Mr. Can you ask your junior to just give me a small list of dates or notes? The facts are too much. By Monday. But the Learning Council for the parties at length. You go through. If there is something, tell me. But I'm not very sanguine with your plea that he should have given up the Mahal. Because before that tenure, he is here before us. Under our eyes. You just give it on Tuesday. I'll have it on Wednesday. But the Learning Council for the parties at length. Hearing concluded. Registered to list this matter again on Budbar. Budbar is an hero. It is. List or delivery of orders. Oh, problem. List for delivery of orders on Wednesday. Just give a small note. If you also want, you can give a small note. Done.
No problem.
Yes, what happened? I'll not go into the whole thing today. We are learning. Whether the matter was referred to the arbitrator. Where is that communication? Who is the arbitrator?
Besides, definitely. Annexure 6, Lordship. Second class.
You had also participated in the arbitrator's proceeding. This communication is of 20 March 2021. That is after the institution of the present proceeding. What do you say on this?
We take it up on.
This is too serious. This is WPC number.
021.
There is a specific reference here. Oh. They say there was one order wherein they was reflected as left out. So they have construed it that the matter has been closed. What do you want me to see? Already.
On Monday.
No rush, no rush, no rush. Give him a perusal of this. Copy or a perusal, whatever it's convenient to you. Mr. A. Nayak, Learned Counsel for the petition, Learned Additional Advocate General appearing for the respondents. In terms of the directions passed by this court, by the order dated 1/8/2025, has submitted that he has received his instructions in the matter. Also, Mr. Nayak submits that in terms of the instructions received by him in the matter, the petitioner had already, in the year 2021, undertaken before the department not to proceed with any such matters, and accordingly, the department was under the impression that the present case was already disposed of. Also, Mr. M. Sahibullah, Learned Counsel appearing for the petitioner, submits that he has got no instruction in this connection and accordingly prays that the matter be taken up on 14/8/2025, on which date he shall complete his instructions in the matter. Also, in view of the said situation developing in the matter, the petitioner is allowed time till 14/8/2025 to complete his instruction. A registry to list this matter again on 14/8/2025.
Deeply obliged.
You have gone through? Anything left? And if you want, you go and institute a criminal case also.
About the
I'm not saying if you want to withdraw it, or I'll pass orders. I'll note that in view of the show cause notice issued to so-and-so, the petitioner is satisfied, and accordingly at this stage, he wishes to withdraw this writ petition. That will do. Mr. S. As Alam, Learned Counsel for the petitioner. Also heard Mr. A.K. Ghosh, Learned Counsel appearing for the respondents. Appearing for the Panchayat and Rural Development Department. Mr. J. Handick, Learned Counsel, Learned Government Advocate, appears for the respondent number 3. So, Mr. Alam, upon perusal of the show cause notice issued to the respondent number 7 by the departmental, where is that show cause notice? Good, you have a copy? (21.5). On perusal of the show cause notice dated 21/5/2024 issued to the respondent number 4, submits that he is satisfied that the respondents have instituted action in the matter with regard to the misconduct committed by the respondent number 7. Also, accordingly, he submits that he be permitted to withdraw the present writ petition with liberty to refile the same in the event a fresh cause of action in the matter so arises. Also, in view of the said submissions made by the learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal. Full stop. However, liberty is granted to the petitioner to approach this court and or any other appropriate forum in the event to approach any appropriate forum in the event there is further there is a fresh fresh cause of action arising in the matter. Also, before parting with the records, this court observes that it is expected of the respondent authorities that the departmental proceeding instituted against the respondent number 7 would be taken to its logical conclusion in accordance with law. Huh? Hello?
50.
Yes, where is the pension payment order? You were given the documents. You were given the documents.
It has been sent to
Oh, you have sent it. What happened? Have you received? So the suffering of the petitioner is prolonged.
Actually, several times we have requested document.
Sent by registered post.
Last time, my lord, email ID was also provided, my lord.
Have you sent it on mail ID also? A forwarding letter is only address, no mail ID. What is the address you gave them?
(23)6 order, my lord. rc.meena66@nic.in. And another Shekhar.
Secretary EZ section. Freedom Fighters Division. But this address is something Under Secretary, Ministry of Home Affairs, Freedom Fighters Division, Policy Section,
Yes.
second floor, NDCC 2 building, opposite Jantar Mantar. It is saying Jai Singh Road. No, opposite Jantar Mantar is missing. New Delhi, 110001. And a government not having an address of the state government not having an address of this central government authorities unheard of. Mr. B.J. Talukdar, learned senior counsel appearing for the state respondents, has submitted that the report in connection with the eligibility of the petitioner hearing to receive pension. Swatandra Sainik Sanman Yojana pension, being the daughter of a freedom fighter, has been forwarded to the Ministry of Home Affairs, Freedom Fighters Division by the Home and Political Department, Government of Assam on 31/7/2025. Also, Mr. Paras submits that a copy of the communication along with its enclosures have also been handed over to Mr. Parasa, learned CGC. Give him a complete copy. Also, Mr. Parasa submits that he will complete his instructions in the matter within, on or before 19/8/2025. Also, this court requests Mr. Parasa to forward the documents received by him today by way of email to the concerned authority of the Government of India for an early resolution of the issue involved in the matter. Also, on the next date of listing, Mr. Parasa shall apprise this court about the further developments that have taken place in the matter. Also, it is expected that on receipt of the report now forwarded to the authorities of the Ministry of Home Affairs, the pension case of the petitioner would be expeditiously processed, considering the fact that she has been deprived of the said benefit, family pension benefit, after the death of her mother had occasioned on
Lots 21/5/16, Mel.
21/5/2016. A copy of the communication dated 31/7/20, the copy of the instructions furnished by Mr. B.J. Talukdar, learned senior counsel, is kept on record and marked as X.
8, Mel.
We have fixed it on 20. I'll register it to list this matter again on 28/2025. Aha. Today you will get it. To my idea. तुम्हें जो माइल वाइकिंग. On the prayer of Mr. J. Handick, learned counsel for the the government advocate, register to list this matter again after
19
after 2 weeks on a date to be fixed by. Come back.
Fixed date loss.
Huh?
Fixed date loss.
Every case is difficult. You come back, we are here. Make a mention. I'm here.
Lost.
Don't worry. Yes.
Lordship, my senior is Lexin another called Lordship. Lordship, he is sir.
You have not filed your reply.
My lord, this is received by me on my lord, this is been 5, my lord, 5th of this month. My lord, this affidavit I have received, but lordship will get it, this is not as per the concerns of the order that is been passed on my lord 14/5. Simply affidavit, my lord, without supported by any document as per the direction.
You bring that on record, we will clear it.
Yes, my lord, I'll file.
Mr. P. Monto, learned counsel for the petitioner, submits that an affidavit on behalf of the respondents has been received by him on 5/8/2020.
Drop this.
He submits that he would file a rejoinder thereto on or before
2 weeks, my lord.
on or before 28/2025, registered to list this matter again on 1/9/2025.
Awesome, Mr. My lord, instead of
Include-
19, my lord, that can be, my lord,
Any date, please.
keep on, my lord. This is
Keep
on
on, no
third,
problem.
third of this, my lord, November.
Okay. Third of,
Third, ninth.
third night, P9.
Yep.
But I'm not receiving the instruction, Lordship.
What happened to your rules?
That, Lordship,
You have sent it to the government of India.
yes, Lordship,
What happened?
communicated, but
Right? Yes, state, Mr. Talda, what happened to your rules? Not following it up. Mr. Talukda is a senior counsel, so he is expected to be everywhere. A mistake on the part of this court. Whenever we see him, we think that he has something to say. No, I'm sorry, I got it. Mr. S.S. Roy, learned, heard Ms. A. Saikya, learned counsel for the petition. Mr. S.S. Roy, learned CGC, who was requested by this court to receive instructions from the Ministry of Health and Family Welfare with regard to the status of the processing of the rules formulated by the state government in the matter, submits that he be granted a further 10 days time to complete his instructions in the matter. Also, prayer accepted, a registry to list this matter again on 27/8/2025. Mr. Please use your good office. No, I think you will have to talk to them. Because this is something which is very, very necessary. Please don't take it as an adversarial litigation. This is in a form of a, we can call it a PIL basically.
Who's affected, but when caregivers are
We'll have it. Let us see what happens. Let us go step by step. The rules being notified, we reach somewhere. Then let's see where we'll have to take it. We'll take it. Assist us, we'll do the needful.
On payment of the share of the land acquisition, my lord. Earlier occasion, Lordship has directed the respondent to file their affidavit by 4th. So Lordship was directed to release the matter to. But they have filed their affidavit on 5th, my lord.
Oh,
My lord, land was.
you want to reply?
No, my lord.
No.
My lord, actually, the present affidavit is in contradiction with the earlier affidavit, my lord.
We'll have to have that affidavit on record. That is not there.
My lord.
Mr. N.K. Kalita, counsel for the petitioner, submits that an affidavit has been filed by the respondent number 7 on 5/8/2025. Also, the said affidavit is not on record. A registry to trace and tag the said affidavit along with the records of the matter on the next date of listing. Registry to list this matter again after.
Next week, my lord.
Next week, the week thereafter, full. Quota complete. Thereafter.
Thought that because the land was acquisition, my lord.
19.
Obliged, my lord.
Your lordships.
L1 IA first.
You have not filed any objection in the stay vacating application?
Not as yet. What is it? And
No, we had passed that order.
yes, we have not filed it for me. An application.
Have you filed an affidavit in the main case? Affidavit, okay, argue.
And I will file a reply to this.
That is why we
Because this
clearly
is,
stated
this is
that
an application, yes, I am aware, my lord. It could not be done, my lord. This is an application under 226(3).
forget it. We
Yeah,
only
this-
treat it as a application for vacation.
Reply, my lord. I'll file a reply. If this is to be treated as an affidavit in opposition,
This is the operation of that cattle. By the panchayat. He is a lessee. No, Ms. Chaudhary, one query. There is a cattle market, okay, prior, after, different thing. Cattle market opened by the Panchayati Raj institution. And at the same time, there is a cattle market being operated in a private area. Now, the revenue of the panchayat is affected. The revenue collection is affected. What would be the option on the part of the Panchayati Raj institution in this matter, in this connection? Can they also take a plea that this market is not to be allowed to be run because we have now a market on our own? They cannot. Daily, only Friday. Both the markets on Friday. And you agree that you are not interested on Friday. When will you run?
Friday is because
You require on Friday, she requires on Friday. Okay. Which is the way from where the cattle moves? Which one will come first, yours or hers? No. Cattle will move in from one direction. Otherwise, there would not have been a contest here. If yours is the first one, she suffers, which admittedly seems to be. That path that is followed, the first one gets the maximum. Is it not, Mr. Abedin? Expert.
That is that the.
Oh, that is why he is sitting there and very attentive to you.
No, actually, I would have
just
come.
want to hear the
No, no, I-
argument into the.
Ah.
But
Lordship, may
I filed
take it
a.
up at 2 p.m.
I'm sorry, I have been asked to get up today at 1 p.m., 1 o'clock. I can't. The causeless it is written. 1 o'clock I should get up, so I'll have to. We have a function, we'll have to be there. Monday, whole week, I'm sorry. I can't even look that side because it's awful, full. We'll have it on Thursday. Thursday, no, what is it? Huh? Oh, Kundinapari, earliest. Marbo. Huh? Next Friday, I'm not coming. It's 15th August. 15th August. We can meet outside. '20th. 20.
I have the.
We are allowing it today only. Where is that I?
That is not there, man.
Okay. Done.
I can give the filing.
Today is 8th. Let this matter come up on 13th. We'll allow the IA. We'll hear the matter on 26th. Complete final hearing. 26. 26. 13 because I'll have to give him a week's time to respond. 26, we are fixing the matter for final discussion.
I'll not.
You are not filing.
Can be taken up on 20th.
20th. Okay.
I think,
Okay.
my lord, if your lordship writes the filing number, so that will be tagged, my lord.
No need. We allow you. Your impleading is allowed. On that day, we allow you. You're not filing any counter. Huh? So on that day itself, we will allow your impleading and we will hear you. Why are you filing objection?
Item, Lordship.
No, who is he? Landowners. So you are not the landowner. So he is also landowner. So both landowners will be here together. We'll hear together.
That can be.
Whether he is this side or this side.
No, no, this side.
This side.
It's a precautionary application, my lord.
Then, Mr. Chaudhary, Ms. Chaudhary, what is the harm?
I'm supporting her.
I have not gone through.
But be careful. It's a petition by Mr. Abedi. Be very careful. We have experience on that. We have experience also that side of being ousted from a writ petition by the pleadings.
Paragraph 31.
31. And that I came to know only when I stood up for arguing. I was I was ready. H.R.H. Chaudhary sir was the side. He was assisting. And I was that day full prepared. No interim, nothing. But and then it was pointed out, para 31 to me.
As a gentleman, my lord, I pointed out.
And I had to withdraw from the brief. So be very careful.
I will also file my.
Item number 2324. Heard the Lanark Council for the parties. Also, the Lanark Council for the parties have submitted that the present writ petition is to be taken up for final consideration. Full stop. 21st, Thursday. Accordingly, Madam Goel, we are having it on 21st. Accordingly, registry to list this matter on 21/8/2021-25, along with any pending interlocutory applications. Also, parties to exchange their pleadings on or before 19/8/2025.
Yes, I understand, my lord. But before 15th was not a problem.
Okay, 26. Madam is asking 2 days will not do anything. Heavens will not fall. 26. But all pleadings before 20th you will have to complete.
And says he will not serve. But since I will be filing affidavit in opposition. That
Analogous matters.
happened.
I understand, but I'm filing for impleading myself in item 24. I have
No,
nothing
no,
to do with 23.
that she has got no problem. If it was somebody else, she may not even have asked for. It is you, that is why she is asking. So
My
give
lord,
her
I'll serve a copy, my lord.
15th for implement.
No. We impleaded. Impleaded, don't make any objections. He is same as you.
My lord,
Then,
I think if your lordship is doing it, then let me, then there may be an order for impleading, and in the meantime, the record may be called, my lord.
no need. We on 26th morning, first thing I'll do is I'll implead you. Then we'll hear you.
Okay.
But pleadings,
Copies,
copy he'll give it to you today only.
I'm grateful.
Done.
And the interim order may continue.
Interim order to continue till the next date of listing.
I'm grateful.
Whether it will be there. Okay. Deeply obliged.
Yesterday, an reply affidavit in opposition has been filed by the NHI. There I have received from my clerk lordship. Wanted to submit a reply of that.
You're only. What is this? Any private respondent here?
No,
Have you taken steps on all?
yes, lordship. For all government.
But here it says steps to be taken by registered post with AD as well as through usual process within 5 days.
No, Lordship, I don't know. Last occasion, their case was listed. There is nothing. All government side. Wrong, probably
I may be wrong in reading it.
Yes,
Please go
Lordship.
through it.
Last occasion, I was present in the court, Lordship. 18/7/25, Lordship.
That is the order. Okay, give it to me. I'll rectify it.
Appear, my learned friend
Okay.
also appeared on
Okay.
that day. He sought time for finding.
M. Dev, learned counsel for the applicant, and Mr. C. Borua, learned standing counsel, NHAI. Also heard Mr. M.R. Adhikari, learned counsel, learned CGC, appearing for CGC, and anybody else, Mr. S.S. Roy, learned government advocate for government advocate. Also, it is submitted that Mr. M.R. Adhikari, learned counsel for the respondent number 1, would accept notices on behalf of M.R. Adhikari CGC would accept notices on behalf of respondent number 1, while Mr. C. Borua, learned would accept notice on behalf of respondent number 2 and 3. Mr. S.S. Roy accepts notice on behalf of respondent number 4, 5, and 6. Notice, first, as all the respondents are represented, no formal notice is required to be issued. You've got your copies. Also, Ms. M. D submits that an affidavit an objection has been filed by NHAI on 7/8/2025. Also, the said affidavit is not on record. Registry to trace and tag the said affidavit along with the records of the matter. I-8 Marivade, IAC, huh? Also, Ms. Deb submits that she be granted 2 weeks time to file her rejoinder to the affidavit filed by the respondents. Prayer accepted. Registry to list this matter after 3 weeks, along with
maybe after 2 weeks.
after 2 weeks, after 2 weeks, along with the further pleadings brought on record by the respondents as well as by the petitioner.
Public.
Full?